guys. I'm going to speak to you in English. I feel very bad about this. I took Spanish in high school. I did not retain much. I'm sorry. But anyway, if you have questions or if you want me to slow down or anything, just please let me know. I'm here today. I'm here for this conference that's going to be tomorrow and Wednesday. Phil asked me to come here and kind of talk a little bit about what's going on in the United States, and specifically talk about the surveillance technology that we have in the United States. Because, as you know, once we get in the United States, it's coming south, okay? And you guys are going to get it too. If you don't already have it, you're going to get it, okay? So you have to understand, my hope is to get you guys to understand what's going on with the technology and to get you to understand some of the legal problems we're having with the technology. And hopefully you guys get a sneak preview so that when it finally comes here, again, maybe it's here already, I'm not sure. Once it gets here, I'm sure a lot of it is already here. Once it's here, you guys can, you can work together to find ways to challenge it and keep the government, from abusing its technology for bad, okay? And when I do this, I've given this presentation before, and I gave it to a bunch of judges in the United States. And I didn't focus so much on the technology, but I've changed it to spend more time talking about technology, because I'm here in a hackerspace, and there's a bunch of technologists, right? Mm-hmm. So, but when I talk about it, I say surveillance technology in the law, present and future. Really, what I mean to say is past and future. That there really is no present, right? That the technology is changing so fast that by the time the lawmakers and the courts start to figure out whether the police can use it or not, it's too late. They've already moved on to the next thing, okay? And the law, because I'm a lawyer, the law is always a step behind the technology, okay? In the United States, we have, our law, we have a constitution in the United States. It's old. It's very old. It was written in the 1780s. And in that constitution is this amendment to the Constitution, the Fourth Amendment, the one that matters the most when you talk about surveillance. And what it says, and as you'll see when we talk about technology, and this is what it says. It basically says the right of the people to be secure in their persons, houses, papers, and effects against unreasonable search and seizure shall not be violated. And then the second part of it talks about really that the government, anytime the government, whether it's the police or the military, whatever, anytime they want to do a search or a seizure, which is taking something, they have to get a search warrant, which is basically they go to the judge and they explain to the judge, we want to search this place, we have probable cause, we have a good reason to believe there's evidence in the place we want to search. What you notice about this is two things. One, it doesn't say privacy, okay? The Columbia Constitution says privacy. The United States Constitution does not say privacy. It doesn't say privacy anywhere in this text, okay? And you see that, and you'll see why, because that's going to become a big problem. The second thing is it talks about persons, houses, papers, and effects. It doesn't talk about data. It doesn't talk about gigabytes, computers, files. It doesn't talk about pictures. It doesn't talk about location. It doesn't talk about metadata. It talks about persons, houses, papers, and effects. And so the problem in the United States is we have to make, anytime we want to make a legal argument to the technology, we have to fit it into this definition that was written with years ago, right? Almost. And as you can imagine, it creates problems. One judge said 2 years ago in a case called Jones, this is a case that involved the police put a GPS device on a car to follow a car. And he said the real problem is while we want to protect privacy, or we want to protect people's rights in the way that it existed when we wrote the law in 1787, it's impossible to think about. They did not have the technology in mind that we have today, that the technology has outpaced the law. The way I like to think of it in a picture format is these guys, they wrote the Constitution of the United States. These guys had no idea what this was going to do. This is Google Glass, right? These guys could in no way have envisioned this. And yet we're trying to fit the law to adapt to this. And it creates problems. We're going to talk about the legal problems later. But first, let's talk about the specific technology. Cell phone tower, okay? Everyone has a cell phone in this room, I bet. I've been here for a day. I was walking around. Everybody's on their cell phone. That's just the way of life anywhere in the world. Well, with cell phone towers, and I don't know how to configure it here, but in the United States, and I'm sure it's the same here, the cell phone towers keep a record of which cell phone tower you connected to. So when I'm walking down the street, right here on Calle 44, okay, and I have my cell phone. Now I don't have service, so I don't have to worry about this problem. But let's say you have your cell phone and you have service. There's a cell phone tower somewhere nearby, I don't know where, okay, that your phone is connected to that cell phone tower. And the cell phone company has a record that you connected to that tower because they want to bill you for it, okay? And when you take that information, you take all of those points, you can get a really detailed picture of where a person has gone over an extended period of time. Here's an example. This is from a case that we worked on. This is a map in a criminal case where this is of Baltimore in Maryland, which is a city in the East Coast by Washington, D.C. This is a list of all of the Sprint towers in Baltimore area. This is just Sprint. Sprint is only the third largest cell phone company in the United States. Verizon and AT&T are much bigger than Sprint. These are just the Sprint towers. And these are not just the Sprint towers. These are a list of all of the places that this guy, Graham, connected to over a 6-month period of time. In fact, what the government did in this case is they got 220 days worth of his cell phone tower location. And it basically put him at 29,000 different specific spots. And they could use those points to say, hey, you know what? Some guy robbed the bank. And the bank was at this location, and the bank was robbed at 12:30 in the afternoon. And it just so happens that Graham was across the street from the bank at 12:30 in the afternoon. And then he drove 10 miles or 20 kilometers north, and then what did he find 20 kilometers north? He found the money that they left when the cops made it. So they were able to put him at the scene of it. In this case, the government got all of these records without a search warrant. They went to the cell phone company and said, we want these records. The cell phone company said, sure, here you go. And they got the records. They didn't have to go to a judge and say, you have probable cause to believe this guy Graham is going to, there's going to be evidence in these records. They were just able to get the records. Yeah.
When you sign your cell phone contract thing, it says you are allowing them to store that data.
Yes. It says, the cell phone contract, what it says is, you understand that we will turn over information to law enforcement if we are required to do so. And we're not going to tell you about it, and you don't really have a right to challenge it. Too bad. And what the courts, and we'll talk about this later, what the courts have basically said is if you don't like this, your solution is to not have a cell phone. Which in 2014 is not realistic. Right? You have to have a cell phone. You're not going to make it without one, right? So this is the way they're using this technology. And I'll say, this comes in every criminal case that I see, the government is doing it. And they're saying, this guy was here at this time. And if you think about it, this is very aggressive. Because if you think about surveillance, we always think about real-time surveillance is very dangerous, right? Like, the police are following where I'm going in real time. They're listening into my phone calls in real time. If you think about it, this is even more dangerous. Because what the police are able to do is they have a time machine. They can go back in time. They can say, you know what? What was he doing 2 years ago? Let's go find out. And they can go to the company and get the record. Now, the United States does not have data retention. Okay? So the companies are not required to keep this information. They can get rid of it if they want. And what we see is the companies have different requirements. Some companies keep it for 18 months. Some companies keep it for 5 years. And you're kind of at the mercy of the company-specific procedure. But there's been legislation to, hey, you know what, we should require the companies to keep the data for 3, 4, 5 years. In fact, that's a proposal, because everyone is mad about the NSA, that one of the proposals, we don't like it, but one of the proposals was, okay, fine, just let the companies keep the data for even longer than they would otherwise, and that will solve the problem. It doesn't solve the problem, but that's one of the approaches. And this is one of the types of technologies that's really problematic.
And they are always going to be allowed to keep that information in hands of
the company. The problem is the government has argued, and the companies argued, look, it's our billing records. We can keep our billing records as long as we want.
It's not like it's your data. No, it's the
company's
data.
The company.
So that's the thing. It's not like they're asking information, but because it's not your data, it's their data. It's their personal logs and stuff like that. It's not their logs.
What we've been able to do in some cases, and more on the state level than in the federal level, we've been able to convince the courts to say, okay, you know what, this information is so revealing that we're going to require the police to get a search warrant. but there has to be some judicial supervision. That they have to go, they have to convince the judge there's probable cause, and the judge can supervise the process. But in this case, that wasn't the case. Now the case is up on appeal in the Court of Appeals, and we'll see what the court does. But most of the federal courts, this is a federal court, most of the federal courts have rejected a requirement for the search warrant, and in fact they said the company's records. I argued one of these cases in the Court of Appeals, and the court said, well, why then don't get the stuff? You know, but it was a 65-year-old judge, right? She probably doesn't want a cell phone. That's her. That's fine. But I'm 31. I need a cell phone. I don't have a house phone in my house. Right?
But your cell phone is not you. I mean, these people only can prove that Graham's cell phone was there.
Right.
Not him.
Right. That's very true, and that's an argument that gets made. The problem is it gets made unsuccessfully many times because it's you know, they'll have a list of, you know, when a guy gets arrested, they'll say, okay, fill out your information, and they'll say phone number, and they'll put the cell phone number, and or they'll search his cell phone and they'll see the phone number in his pocket had this phone number that was in the phone, right? And so you're right. All they can say is a data point that this cell phone was in that area. And Graham could say, it wasn't me, I gave it to my brother on that day.
Yeah.
But then that's on him to prove it.
Yeah.
And that's an obstacle. That makes it very hard for him to do it. And this is very powerful evidence. I told you I gave this talk at a conference a few months ago in front of a bunch of judges. And one of the judges came afterwards and told me and said that he had a trial in his courtroom where the prosecutor presented this type of evidence, where they had a map and they showed the defendant, the guy on trial, they showed that he was across the street when the bank was robbed, and they traced his movements, and that he was next to the co-defendants, because there were 3 or 4 other people charged. They were all together at the same time in front of the bank. The jury deliberated for 10 minutes and they convicted him. This stuff is very compelling, and the juries, they want to see this stuff. They watch TV, they see the movies, they see all this stuff. And they this is how, like,
I mean, you put a mask on yourself when you are going to. I mean, the criminal mind is going to put a mask on himself. So the people can just change their cell phones just for the moment of the robbery. Yeah, it's like. No, la portada es. ¿Cómo se dice portada?
Well, they could.
La negra.
No ganarán, pero va con otra.
Yeah, it's like putting a mask. So instead of putting a mask, just change your phone.
Change your phone. Well, we'll talk about changing your phone because it doesn't really work all that much. Because they can connect the phones. They can find, if you change your phone, if you use a burner phone, and they dump your phone, you get a new phone, they have a way to connect those phones. And they do it all the time. In the United States, they do it all the time in drug cases without any judicial supervision. What they do is they go to AT&T and they say, we're looking for this, we want you to run some analysis for us to help us find the correct ones. Actually, this is unrelated, but I was reading an article about how they caught Chapo Guzman. That's how they caught Chapo Guzman. Because he had, I mean, if you read it, it's very interesting. They said he communicated only with BlackBerry.
Okay.
And as they were getting closer, this is what he started to do. Someone would send him a message on a BlackBerry. The person and they were able to say, you know what, we think he's in this general area, or we think it's this guy is the guy sitting next to him, and that's how they infiltrate, and that's how they eventually caught him.
But yeah, in Bond's movie, this guy just buy a new phone. I mean, it's a new one.
Yeah.
So I don't know. I know that this stuff works.
Yeah.
But I think that
that's very different, you know?
Yeah.
And that they are actually using it that way. I mean, because we are, I don't know if you have seen they're making patterns
Yeah.
on people that used to be criminals, and then they start to see like, okay,
Minority report. Besides minority report.
Yeah, I mean, it's a joke, right? We see it in the movie. It is real. In Chicago, for example, they have a list. They call it the heat list. They hired a researcher to create an algorithm to predict who is likely to commit a crime. I'm not joking. I'm not making this up. You can search for it, okay? Now, how did they create this algorithm? Well, they took data that the Chicago police had compiled on arrest records and conviction records and who people associate with, or what neighborhoods are more violent or have more crime than others. And anyway, they did this algorithm. They came up with a list of 400 people in the city of Chicago. Chicago's a big city. So what they're doing is they're going to each of these people, and they're saying, hey, we want to talk to you. You're on our list. Let's just stay out of trouble. But if you need help, we'll help you. If you need help finding a job, do you need, here's resources for school. So on the one hand, okay, that's good. Try to get them services, help take them away from crime. They do all this stuff. They try to predict where the crime is, so forth. Which, in my mind, is okay. I guess if you can do that, and I don't know if you can, but that's a kind of a scary thing. Like, crime is not predictable sometimes.
Yeah.
Sometimes a kid makes a stupid decision in the snap of the moment, and he's high on drugs or whatever.
Not as well done.
Shit happens, right?
Yes.
And can you predict that? You think this is crazy? Ever heard of a stingray? So stingray, little fish that swims in the ocean. This is a different kind of stingray. Okay? Stingray is basically a man in the middle attack of cell phone networks. It's basically they know you're in this building, but they don't know where specifically. They put your phone number into this machine. Then what this thing does is it starts to scan the area to look for signals. And basically, if you make a phone call or you send a text message, you're going to send the message is going to go through the cell phone tower, the big one up in the sky. If the stingray is in the area, before it goes to the cell phone tower, it's going to go through the stingray, and then they can figure out where you are. These things can be configured to figure out, to capture your communication. So it can intercept you.
How's the cell phone tower? Like us.
They use it in two ways. Let me explain how they use it in.
Yeah.
Exactly. They use it in two ways. The first way is if they know a specific phone number and they're looking for that person, they can basically put the phone number in and then drive around the city until they find it. Okay? Now look, in a big city like Bogota, that's kind of impractical. Yeah. Well, let's say they've narrowed it down to like a mile or 2 miles, a few kilometers, or they know he's in an apartment. One case we saw was they knew he was in an apartment complex. The complex had 200 apartments. So they didn't know which apartment. So they literally walked around with this thing until they were like, he's in that one. Okay? That's the first way to communicate. The second way they can do it is, let's say there's a big protest, and they're not looking for anyone in specific. Instead, they're trying to identify all the people in the protest. What they can do is they can go to the protest, they can park it outside, and then they can just see, okay, let's scan the area and see who's here. And they capture everyone there, and it captures your IMEI number or your IMSI number. They can capture, which is a unique number that is associated with your cell phone. So then they can then say, okay, here's the number we have. Let's figure out which provider. Okay, it's Sprint. Okay, let's go to Sprint and say who's the subscriber. And then they'll say the subscriber is Hanni. Well, now they know I was in this place at this time. So that's how they use this thing. They also can do the second thing I was talking about, trying to identify who is in the area. There's another way they can do it, but they don't even have to use the Stingray. They can go to the cell phone company and say, give me a tower bill. Where they basically say, that cell phone tower here on that corner? We want a record of every single cell phone that connected to that tower over a 2-hour period, right at the time of bank robbery. And then the cell phone company will say, sure, here you go. And then they can look at that information, and then if they're looking for a suspect, they can use it. They can go this complicated analysis, right, to figure out who is the one that they should focus their attention. What's crazy about these Stingrays is all the police departments have them, and nobody will admit that they have them. Okay? And the reason they won't admit that they have them is that there's only one company in the United States that makes these, a company called Harris. And Harris makes the police departments promise not to say anything about the fact that they have them. Okay. So what ends up happening is the police will use these things and then they won't tell anybody that they use them. Or they'll go to the judge and say, hey judge, we want to get an order telling the Tigo to give us records, and then the judge will sign the order thinking he's ordering Tigo to give records, and then what they'll say is, okay, now let's use the Stingray. And then they'll go around and use the Stingray. So this thing is, we're doing a lot of work trying to figure out who has them, how they're using them, the judicial process for using them, but there's a lot of silence about it. No police department wants to admit that they have it. The FBI, their policy is that they direct agencies and agents not to admit that they use it, that they're supposed to keep the use of the secret. Even from, we've seen directly, even from the judges who are authorizing it. They won't admit that they produce. But they make a bunch of equipment for law enforcement. Like they make a whole bunch of other communications devices. But if you go to their website, you won't see any mention of the product.
I think I have seen one of the system open source in that qualification.
Yes.
Someone did that.
Kristen Paget did it where she demonstrated how this thing worked, and it's pretty cool. Yeah. And Chris is going ahead and knows. I don't feel Chris is going to want it. Okay, another thing that we have, and we probably have these, is license plate readers. These things are cameras. They're usually, you find them in two places. One is they're mounted, so there's a police car, you see the camera on top of the police car. The second is they're in a fixed location, like at a particular intersection. What these things do is they take a picture of every license plate that drives in an area. And then what happens is the police department keeps a database of all the license plate numbers that drive through in the area. And what ends up happening is, theoretically, what they're supposed to do is they're supposed to figure out which car is stolen and which car is not. Like, that's the whole idea. Like, oh, this car in front of me, if it's in the police car, you're driving, you're the cop driving the car, and the car, and the license plate reader alerts, okay, and it says, hey, this car is reported stolen. Then theoretically, like, okay, now this car is reported stolen. I can pull the person over. I can call for backup. That's theoretically what they're supposed to do. That's, they capture a lot more records. In Los Angeles, I just picked Los Angeles at random, there's 160 million data points in the county of Los Angeles. The city of Los Angeles is a big city. Almost half, it's not the size of, well, I thought that it's, almost 4 million people live in the city. They captured over 160 million license plate records. Well, people just drive, you're just driving to work, you're driving to school, you're in their data. Okay? And in fact, we filed a lawsuit challenging, we requested some records under our public records law. The Los Angeles Police Department wouldn't turn the records over. We filed a lawsuit, and in the course of that lawsuit over it, the LA police said that every license plate is an investigatory piece of data. What that really means is that we treat every car as a suspect. Okay? We don't know what cars are stolen, what cars are not. We don't know which cars are, going to be used as a getaway car for the bank robbery, so we're just going to treat them all the same. They're all under investigation. That's what they said in a court filing to a judge. That's what they said. This is how the police departments view this data. And there's a very weird confluence, right, between the private companies that make these devices and the government. So, for example, there's a company that makes these devices called Vigilant. And they offer to a city in Arizona, a city called Tempe, they basically offer to give the city free readers on the condition that every month the police department would make 25 arrests based on their license plate readers. So what the fuck is that, right? The company is dictating to the police the type of surveillance to do, and then the police then has an incentive. We have to meet our quota so we don't have to pay a bill for them. It's ridiculous. Now, thankfully, the police department declined. This specific police department declined. But who knows? I mean, the fact that they offered suggests to me that there are other police departments that are maybe poor and don't have the same type of money and don't have the same type of resources to say, free surveillance software, free surveillance technology, sure, we'll make 25 arrests. No. There was a case in San Francisco where the police used the data made a mistake. Okay? They were following the car, this was on top of the car, they followed the car and the reader misread the plate. But the police didn't realize that the reader misread the plate. So they pulled the car over. There was some lady driving home from work, never been arrested before, because the hit showed that the car had been stolen. They dragged her out at gunpoint. They forced her to the ground. They waited. It took 20 minutes until they realized that the reader had read a 7 as a 3. Okay? That was the mistake. And they spent 20 minutes with guns at this lady. It's ridiculous, right? And of course, she sued, and the city's going to pay a lot more than they paid to get the readers. And I mean, it's kind of a funny story. I'm sure it wasn't funny for her when she's on the floor with a gun in her neck. But I mean, this is the problem too. The over-reliance on technology without doing the homework. Like, if we're taking 2 minutes to just see that the license plate was misread, and they would have spared the lady the terrible experience and spared the city the money and the time and expense of the litigation, but they didn't do it that way. There's another thing. The FBI is building what's called its next generation identification database. They're building the FBI has a number of big databases. For example, they have DNA data. Anytime anyone in the United States gets arrested, their DNA goes into a database. Doesn't matter if they're convicted, doesn't matter what they're arrested for. It goes in the DNA database. And it stays in the DNA database unless you ask for it to be removed. And it's not very. So that's one of their very big databases. Another database they have is this new NGI database that they're building up. And what it is basically a consolidated database of many different biometrics. So it has palm prints, okay, your iris scans, fingerprints, and most importantly, it has facial recognition. Right now, it has 100 million individual records, and it has 16 million pictures in it, but they estimate that by next year, it's going to have 50 million pictures. 50 million pictures of people. Now, where are these pictures coming from? The bulk of the pictures are coming from crime scenes, or when you're arrested in your book, you get your picture taken, but they're in the process of integrating non-criminal pictures too. So you go to get your driver's license, you take a picture. You go to get your green card or do immigration paperwork, and you can take your picture. You're going in the database. Okay. Some jobs require you, if you work for the government, you got to do a background check, and you take your picture. Going in the database. And the real worry is, the private companies like Facebook is starting to do facial recognition. This is why when you log into Facebook, you have 20 alerts. You've been tagged in 50 pictures, and you go, I didn't tag it. How does it know that it's me, right? It's because it detected it. Its facial recognition software is getting very good. There's some worry that one thing will lead to another, and the two databases will get married, right? And will spawn this nasty kid of a giant picture database, right? And of course, right now, the FBI's database is, of course, it's not just for the FBI. It's shared with other federal law enforcement agencies and over 18,000 national, state and local police department. So the San Francisco Police Department, the California Highway Patrol, you name it, they all get access to the data. So it's very scary out there. Some of this stuff is crazy. So that's the technology. There's going to be some more technology to talk about in a minute, but I want to shift for a second and talk a little bit about the law. And I know most people in here aren't lawyers, but I'm going to kind of boil it down so you can see what the problem is. If you remember, I showed you at the very beginning, I showed you the Fourth Amendment, the constitutional protection. And I mentioned it doesn't say the word privacy, and it doesn't say the word data. It says you have a right to be secure in your person's papers in effect, whatever that is, okay, in your home. Now, some of those things are easy. Your home is your home. This is my house. I have a right to be secure in my house. They can't come into my house without searching. What about your computer? It's not, I mean, it's not, is it an effect? I think it's an effect, but no court has really said that, okay? How does the court deal with it? So basically, like I said, oh yeah, sure.
The doesn't because I don't know, in some countries, people can hide the
You can, so there are ways to physically hide your face, right? You go to a protest and wear a mask on your face, they won't know who you are. It's so much harder. The problem with technology is it's harder to hide your technological. Your cell phone is your cell phone. Like, how do you hide your cell phone? You either don't bring it with you, okay? You're going to go to the protest. You turn it off, even though that's maybe not that technologically. Oh, sure. So what I was saying was, if you think about it in the physical world, if I wanted to hide my identity, go to the protest and I put on a mask or I get plastic surgery or something, okay? Extreme measures, okay? But it's much harder to hide your technological identity, okay? And now people have tried, but there isn't great ways to do that. I mean, okay, you can log into Tor and then, spend 20 minutes to get to the website you want to get to. Okay, you can use an encrypted email, which, I understand how to use encrypted email because I'm a lawyer and I do technology. Try to explain that to my mom, who's 65. She's not going to understand what a GPG is. You have a key signing and using a public key. She's going to send an email and you've done it, okay? And we do your cell phone. How do you hide your cell phone? Well, you don't take it with you, which is what we actually recommend to people. Like, if you know you're going to get arrested, you're going to go do some risky stuff, leave your cell phone at home. Yeah. But why are you going to create a data trail for yourself? Why are you going to give the cops everything that you have on? We're going to talk about that in more detail because that's actually an issue that's in front of the US. They're going to search your camera. We actually had one of our employees got arrested at a protest and they searched their camera and damaged it. The Oakland Police Department. They're going to, when they arrest you, they're going to take everything. They're going to look through every piece of data you have. And that's in the United States. And in the country, they're everywhere. It doesn't matter. U.S., Venezuela, Colombia, it doesn't matter. They're going to do it. They're going to look. They're going to look until the court says they can't look and you're going to get in trouble. And right now, not enough courts have said that. So you leave your cell phone at home, or you turn it off, or you don't take it with you. That's really the way you protect yourself. Now the problem is there's a trade-off, right? The trade-off is you don't have your cell phone with you. Maybe you want it because you want to be able to tell someone it's going down, I'm getting arrested, someone I love her, okay. So that's part of the problem. So, like I was saying, the law. I'm going to give you a crash course on U.S. law very quickly so you can understand the legal problems with all of this. So I mentioned that, if you remember, that the constitutional protection says you have a right against unreasonable search. So it doesn't say you have a right of privacy. It just says you have a right against unreasonable search. So what the courts basically said was, well, by search, we mean two things. We mean that you have a subjective expectation of privacy that society is prepared to recognize as reasonable, or the government physically occupies private property for the purpose of obtaining. This is lawyer language. It makes no sense. So let me make it English. Okay. Let's start with the second one because this is easy. If the police come onto your property to get information about you, that's a search. If the police walk in here, it's a search. If they slap a GPS device on your car, that's a search because they trespassed onto your property and their purpose is to get information about you. If they step on your front lawn to use a stingray, that's a search because they occupy private property. It has nothing to do with privacy. It just has to do with intruding on your property. This is a very old-fashioned way to think of it. This is like, you step on my property, I'm gonna, you're gonna have a duel and I'm gonna shoot you or something, right? No trespass. That's what this approach. The first approach is basically an attempt to put a right of privacy into the Constitution. And what it basically says is you have to show two things to show a search. First, you have to show that something you're doing, you intend to keep private. And second, that even though it's not enough that you intended to keep it private, it has to be reasonable. Meaning most people would agree that it's reasonable what you're trying to do. So, for example, you have a backpack, okay? Because your stuff's in a backpack, I imagine you're intending to keep that stuff private, and you wouldn't want me to go and open your backpack and look around. And I think most people would agree that it would be reasonable for me to say, or for you to say that you expect privacy in your backpack. It would be very rude if I just walked in and started looking through your stuff. Okay, that's easy. You have an expectation of privacy. If the police went and looked in your backpack without your permission, that's easy. But then it gets a little tricky because the courts have said, well, if you expose something to the public, even in your own house or in your office, you don't have Fourth Amendment expectation of privacy in that information. So, for example, if I walk around naked in my bedroom and my window's open, and the person down the street can see me walking naked, I can't complain and say I was trying to be private because I've exposed myself in public. Okay. The second thing, and this is very important when it comes to technology, the courts have said you don't have an expectation of privacy in the information you give to other people, that you give to third parties. Now here's the thinking behind it. If I tell you something in secret, and I say, hey, I have a secret, I killed someone. Don't tell me, okay? I'm assuming that risk. So if I really want to keep it private, I should just not tell you. The courts have basically said if you turn data or records or information over to third parties, you also don't have a right to privacy. That's how the cops get the cell phone records without the search warrant. Because what the courts have said is when you turn your cell phone on, you're giving your location to the cell phone company because they're trying to connect your cell phone. So to that, you've exposed that information to the company. It's the company's business records. It's not yours. You've exposed it to someone else. The cops, it's not a search. Police can get it without a search. Yeah. Look at the year of this case. 1979. There was no Facebook. There was no, maybe there was the internet, but it wasn't like what we have today. There's no Twitter. There's no Google. There's none of this stuff. Well, what do people do now? Well, they keep all their email. They don't send letters in the mail. They leave it in their Gmail. People communicate through electronic means. People use Dropbox. People store their data online. The technology, this carries tons of information about me, and a lot of it is not actually in the phone. It's sitting on the provider, like the list of my locations over an extended period of time. That's sitting in a server system. If the government went and got my phone tower records, they would see that on Sunday morning I was in San Francisco, and then Sunday afternoon I was in Miami, and then they wouldn't see anything for 4 or 5 days because I'm not connected to any cell phone towers. And then they would see I came back to Miami on Thursday, and then back to San Francisco Thursday night. And then on Friday, I was in San Francisco in my office, and then after work, I drove to my house. They can figure all of it out. Now maybe there's that 4-day gap, but they can get all sorts of other information. Get my airline record. They can get my credit card record. All of that is information I've given to other parties. They can figure out where I was in that 4-day period, no problem. When I went and checked into my bank, I had to tell them my nationality. I have to show them my passport. You have to scan your passport to get on the airplane. You get a visa. It is very hard to stay anonymous, right? So this is the problem, right? We have an idea that, well, I try to keep some things private, but the courts basically say, if you expose it to the public, it's not private, and if you give it to somebody else, it's not private. But there's lots of things that I intend to keep private that I may expose to someone, and there are lots of things I want to keep private that I keep in the third parties. Like if I have a Gmail, that's my personal email. Okay, maybe Gmail has my messages, but I don't expect Gmail to go and print out all my messages and give them to you. I would get really mad at that, right? Most people would get mad at that. So the problem is the legal framework hasn't kept up with changing technology.
But if I understand good, if I have a Gmail account, that information has been shared by me to Google, so it's subject to.
So you can sell ads to it, right?
Yeah.
So they can sell ads.
So this applies to this area. I did it, so now it's not related.
Right. So that's one of the arguments that has been made. Right?
Anything that is shared is not private anymore.
You don't have the expectation of
You don't have the
privacy.
expectation.
Technically, you are not sharing if a mail in Gmail. Technically, it's not something you have shared like a photo in Facebook. I think.
Well,
But
that's
you don't
actually
expect
that's
that.
the point. That the law creates black and white. That either it's completely private and you've shown it to no one and you never mentioned it to a single person in your life, or by exposing it to some small subset of people for some small set of purpose, you forever surrender your right of privacy, especially with the government. And this is the approach we're trying to attack. It's not all or nothing. There's room in the middle to grip. That even though I have messages in Gmail, maybe I agree. When I sign up for Gmail, I agree. Gmail can scan the messages to send me advertisements. What I don't agree is that they can just turn my messages over to him.
And it's not only that. It's not only your. I mean, you may have a Gmail account, but what if I don't have one and I send you an email? So Gmail's reading it, for doing advertising. It's not reading your email. It's reading my email that I sent you. So it's people that's not agreeing with the privacy policy, and they're using any other provider.
That goes back to what I was telling you, that you assume the risk.
Yes,
This is what the courts have said. You assume the risk that I'm going to send you an email. Even, let's say I don't have it to email. Let's say you send it to my work email, my BFF email, which you don't scan for ads. Okay? You run the risk that I take your message and I'll print it out and put it on Twitter. But maybe our norms are that that's not cool. Like, you and I are friends. I would agree not to do that. But theoretically, what the law says is you run that risk. And, that's between us. The law has nothing to do with it. And that's the problem, right? That it doesn't have the sophisticated, more nuanced approach.
You take measures to make that the information is not so easily shared, or it gets erased in some time. You can assume that because you're not giving it away without worrying for it. You're really taking care of what you are sharing.
Like encryption, for example.
Yes, for example.
Oh, I think within all of this, people have to also take some responsibility. And I don't mean to say that I should be able to say whatever I want and then do that. I think you have to take some responsibility. And, if you really want to have a secure private conversation with someone, you really should send it encrypted, right? You should use, OTR if you're chatting. And, we encourage and train, people all around the world on how to do that. We haven't gotten along yet, but we're getting but the problem is, again, it has to be a combination of all this. It has to go through people taking smarter steps with their data, but at the same time, the courts and the lawmakers recognizing that it's not a black and white thing. That, if I have a Facebook account and it is private to the world, that I allow 200 people in, that doesn't mean I let it the whole world in. A lot of this is still getting worked out. Something like Facebook's 10 years old, and hasn't really been litigated in the courts at all, because it's still it's not new, but it's not old either, right? And that also the courts are slow to keep up. I'll give an example of how the courts are slow to keep up, and it really deals with the expectation of privacy, of what you expose to the public. In the 1980s, there was a case, this is from the U.S. Supreme Court, it's a case called Knox. And in that case, what they were deciding was whether the police, what the police did in that case, again, it's 1983, what they did was they took a beeper and they put it in a big can of ether that they suspected was going to be picked up by drug traffickers. Okay? So the beeper, what it would do is it would send a little beep, 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 and they could follow from a distance. They had to follow. They couldn't just sit in their office and watch. They had to follow from a distance. And so they tracked this car as it drove in the public street. And the car took one trip. It went from one place to another. It was a long trip, like, 40, 50 kilometers. But it was just one trip. So, long story short, it gets challenged, and the Supreme Court says, no, you don't have the expectation of privacy in your public movement. Right? Because you took one trip. Any person sitting next to you could see where you went. The police had to physically follow the car along, because from some distance, they had to follow. And just because the technology made it easier for their eyes, doesn't create some new expectation of privacy. Now, they said, we consider this as some sort of dragnet type law enforcement practice gets developed in the future. But for today, in 1983, we'll leave it like this. Well, what happened? In 2000, you can't see this, is from Breaking Bad. I don't know if you guys watched it. Because what he's holding, it's hard to see. If you remember, if you watched Breaking Bad, okay, it's a GPS.
Exactly.
Right. If you remember, he told Walter White, put the GPS device on the guy's car, right? And that's what happened in Jones, which was a case that came about almost 30 years later. In Jones, what the police did was they got a GPS device, a small one, maybe the size of that remote, and they physically went underneath Jones's car, who was a drug dealer, and they put the GPS device on the car, and then they used the GPS device to follow the car. Now, they weren't following in another car. They were following from their office. They were sitting there eating their donuts and having the coffee, and they were watching the car. Okay? They watched the car for a month. Okay? And they saw the car when they went to its house, when it stayed at the house, when it got up, they followed him all over the place. And so they challenged. They said, this is the dragnet type practice. And they said, the argument was, even if you expose your movements in public in a limited scale, like a discrete trip from one place to another place, you don't actually expose 30 days of your movement because you don't expect anyone is going to follow you.
For two.
In fact, if somebody followed you for 30 days for 24 hours a day, what would you do? You'd call the cops.
Yes.
Right?
Of course.
There's somebody following me who's been following me for 30 days.
Yeah,
It's
we
kind
know,
of
we
scaring
know.
me a little bit. You know, it's us. So, and so,
Don't worry about it.
yeah, don't worry about it. So that's the issue. The technology changed what was considered public, one trip, one discrete bit of information. The technology aggregates it in a way that it becomes something that I don't want anybody to know what I've been doing.
So it happens the other way around. I mean, for example, making these movies about us. There is a right, I don't know, imagen personal.
Public image. The public image, your image.
Yeah, your own image. So yeah, your self-image. So you cannot like film someone without asking permission.
Okay.
But
Now the rule is like nobody asks permission to anybody about making some kind of picture or movie. It's like the new rule because all the people has cameras and stuff. So it's also changing our expectations about what is
Acceptable and what's not acceptable.
Yeah.
You're absolutely right.
You're going to remember this name because there is a guy here, he's called Zuluaga. He got recorded recently without his permission. And we have a law here that says that is illegal. You cannot get treatment without permission. It's like the legal stuff. So for example, even being here, this is a closed space. And the people, it's normal that we take pictures and it's the normal stuff, but following the law, all the people that is making pictures or making movies should ask for the permission of anybody else because this is a closed space. But we don't have that expectation now because we have social networks and stuff like that. So,
I think it's harder. It's harder. Well, I'll say this. One of the problems with this test as a legal principle is to a certain extent it kind of will always change, right? Or is subject to change. So 20 years ago, when technology was a certain way and not everybody walked around with a camera on their person all the time, it would be reasonable to say, I don't want you to take me a picture because it's kind of an intrusive thing, and I have ways to avoid it. Like if somebody wanted to take a picture, they'd pull off the big camera, and I could say, whoa, this guy's taking a picture, I'm running away. Yeah. Now I can be very discreet to do it. So a test, making the law based on this test is problematic to a certain extent because the expectations of privacy constantly change, right? And you know, that's what's the problem with some of these technologies. Like, if the police keep doing this for 10 years, at what point in time are we going to say, okay, society no longer expects privacy in their movements. In fact, they expect to have their movements recorded all the time, so don't complain about it. And I think we were talking about this earlier, with Pilar, about how in Colombia especially, you have a long history of war and conflict, and that creates in people a attitude of, well, that's what it is, And we have it too in the United States, especially after 9/11. People say, I go to the airport, I have to have my X-ray taken to go in an airplane in America. Okay, sure. Whatever. And people get mad about it, and they get upset, and then eventually fade away. So what we're trying to do is to say, look, there are some things that remain important as, I don't know what the right word for it, as a policy judgment, as an ethical rule. And the framework we always say is, look, we're not saying the police can never get this thing. I'm not saying the police cannot use a GPS device. I'm not saying the police cannot take time. All we're saying is we have to create a better balance between allowing the police to do the job and me having some rights. And in the United States, the traditional balance was search warrant, because the search warrant basically says, look, you have a right of privacy up until we get probable cause, and we can convince the judge of that you've done something wrong, or we're going to find evidence against you. At that point, you don't get that privacy protection anymore. And that's the balance we struck. And so a lot of what we're trying to do is just say, look, you have the right of privacy in your movements in public or not. Please. You should expect to keep that information private. It doesn't matter if the technology allows the government to capture that information. You should still expect to have some ability to control what people can see about you. And it shouldn't depend on what is possible. It should depend on what we as a society want to respect as a human right. And that's maybe one way. So yeah, sorry, yeah, exactly. No.
There's kind of the two sides of the story in terms of one thing what the law says, which is kind of what we should do, basically, and the other side of the story which is policy, which is what I should promote as something, well-being or whatever, as something. So what I see now is basically like how the law works, and basically where you shouldn't go, what you shouldn't do, whose responsibility it is for certain things. How does that contrast with maybe the fact that also, like, I don't know, is there policy going towards people being aware of privacy issues, people regulation aiming at companies in having to comply with certain things in terms of privacy, in terms of protecting people's privacy, those kind of things?
Yes.
And how does that sort of balance with this?
So that's actually a great follow-up question, because I think one of the ways, to go back to his question, but I promise I'll answer your question. One of the ways we can get around a test that could change is to have the legislature, have Congress say, you know what, we don't bother with this. We're going to make a rule. Search warrant to track a person's voice. Search warrant to get person's emails. The Congress can do that. And there has been some attempts in the United States. There's been some attempts to do that. The attempts are not perfect. There was a law in the 1980s, for example, that was supposed to protect communications that you keep like on a server, like your Gmail. Okay, but it has now, because it was written in 1986, it's out of date now. I'm not talking about it in this presentation, but I will talk about it on Wednesday at the conference. It doesn't work anymore. The decisions that Congress made are outdated. So you have to go back and revise it. And that's one of the things we're pushing. Revise the law. Create protection. Another thing we're doing is we're saying, because we have right, the federal Congress, which creates law for the whole country. We also have every state can create its own law. We have a very dysfunctional federal Congress, and they don't get much done because they have a lot of politics in it. So what we do is we tell the states, we say, you don't have to wait for Congress in DC to do something. California, you can make your own law. And even though that won't control what the federal officers can do, it controls what the state police do. And that's a gradual step towards bringing stronger privacy protection. So actually, to go back to this for a second, on the GPS device, a lot of states have started to say the police need to get a search warrant to install the GPS device. And actually what I should note is that in the Jones case, the Supreme Court said the police need a search warrant to install the GPS device. And they did not decide the case by focusing on privacy. What they said was, when the police went into the car to install the GPS device, that was a trespass onto private property. That's a search. That means the search warrant requirement applies. Now, I like the result, but if you think about it, that's a very old-fashioned way of looking at the issue. Especially because we've already talked about, they don't, the GPS device is on its way out. It's too much trouble for the police to install the GPS device. It's much easier for them to do the cell phone tracking. It's more precise. Cars can't go into bedrooms. And they can't go, the car stops at the front of the house. But once you're in the house, where's the person? You use the cell phone. And people carry their cell phones everywhere. So it's going to be, and they don't carry their car with them, right? So it's much more precise to track a person's movements with the cell phone. So we need the court to say it's not just the installation, it's tracking a person's location. It's the broader policy thing. We want people to feel secure that they're not going to be followed all the time unless the police have probable cause and a search. And in this case, two of the justices, and I won't get into a lot of detail, this is now we're getting really in the weeds, but basically, two of the justices basically said, okay, this trespass idea is fine, but really people should have an expectation of privacy that their movements aren't going to be followed over a long period of time. And so we're starting to see, again, state courts, state legislatures are starting to address the issue and say it's not just the installation of the device, but tracking the person's location over a period of time. I mentioned the federal courts have not been good on the cell phone tracking data, but at state courts, you have two state court opinions, one in Massachusetts and one in New Jersey, where the court said, you know what, it doesn't matter if the records belong to the phone company, we still think the police should get a search warrant to get those records, and then other states have done it by legislation. They say by statute, our state police can only get this information with a search warrant. Now, the state law, again, it only applies to the police of that specific state, but again, it's a gradual step towards the longer goal, which is to create a national policy across the board. I'll skip this. This is another example about exposure. This is a very famous case from 1986, where what the police did was they suspected a guy was growing marijuana in his backyard. And the way his house was, he had a fence around his house, okay, but like every fence you've ever seen, the fence was just around the house, it wasn't on top of the house. So what the police did was they flew an airplane over his house to see if he was growing marijuana. And it turns out he was growing marijuana. So he must have been growing a lot of marijuana. Right? And so the case got challenged and it went to the Supreme Court, and the Supreme Court said, no, you would expose your backyard to the public. Okay? It doesn't matter if the police officers on the ground couldn't see because the fence was blocked. If they're in an airplane and they're allowed to be in an airplane, that's all that matters. You don't have expectation of privacy to the public. Okay? This is a ridiculous opinion. The problem is, well, okay, police really aren't flying airplanes that much anymore. It's kind of expensive to do that. But it's actually, the problems are that cheaper for them to do that. Because they can use a drone to do it, right? This is a drone, this is a picture of the drone. I found this on Google, but it has a camera. I heard, somebody told me that on the border between Arizona and Mexico, the immigration officials have a drone that has a stingray attached to it. Okay, they're like combining the technology, right? This is like some super spy device, right? So this drone can fly around and it has the stingray and it can figure out who's in the air, right? This is a pole camera, a surveillance camera in a street, right? And I see a lot of these everywhere I go, and there's a lot here in Bogota. I've seen them. We have them in San Francisco. We have them everywhere. We had a case where the police suspected this guy was selling drugs. He was a drug trafficker. So he lived in a very rural area of town where he didn't have neighbors. Like he had a big ranch, and nobody was around. So what they did was they went to the power company that had a power pole across the street from his house, and they put a camera on top of the pole, and they watched the guy's house for 6 weeks. They just sat there and they watched from, and I mean, I literally, the agent said, I would go to work at 9 o'clock. I would load up the video, and I would watch, and at 5 o'clock I'd go home, and the next day I'd go back and do it again. And they did this for 6 weeks until they finally caught him doing something. And it took them 6 weeks because they had no evidence of him doing any drug use. They saw him come home and then leave, and they saw who came to his house, and he left. What did they finally catch him doing? One day he decided he wants to shoot his gun. So he gets a couple of beer bottles and he puts them on his, because he lives in the middle of nowhere. So if you live in the middle of nowhere, you can shoot your gun. You can't shoot your gun in Bogota. You're gonna hit someone. If you live in the middle of nowhere, you shoot your gun, no problem. So he puts his beer glass and he's shooting his gun. Okay, sure, whatever. So they say, hey, let's check to see what his immigration status is. Turns out he's done okay. The crime in the United States, you're undocumented, they have a gun. Boom, they go arrest him. They go arrest him. Did they find drugs? They found personal use amount of methamphetamine. So they started with this one. They said, we're going to investigate him for narco trafficking. They got no search warrant. They installed a camera. They watched the guy's house for 6 weeks. They see him do nothing. Connected to drugs. They get lucky that he happened to fire his gun and he happened to be undocumented, and then they use that to get a search warrant to search his house. Okay? In that case, the judge was not, he was nervous about the thing. He actually called us and said, can you file a brief and tell us if you think this is constitutional or unconstitutional? He said, this is very unconstitutional. And because, the furniture of your house is protected. We don't know what the court is going to do. He hasn't ruled it. But I mean, this is how the technology gets used. And I mean, the police have a camera. Look how small the cameras are. There's one right there. It's like the size of it's tiny. It's smaller than my cell phone. And they can just have it running all day. And that's what they do with those ones here in public. Now, you mentioned you were mentioned about taking your picture in public. I can't really complain if somebody takes one isolated picture. But think about how these technologies work together. So they have a camera on every corner of the street. They take your picture. These cameras are going to get facial recognition software on them. So when they take your picture, they're going to say, oh, that's Hanni. Let's see where else Hanni has been. Let's get his cell phone tower record. Let's figure out which other cameras that have facial recognition have Hanni. Oh, he was in this block at this time. Let's pull the camera footage. They're going to connect all of this together. And then all of a sudden you lose the ability to just go about your business without anybody knowing what you're doing. What the government is going to say is, look, you got nothing to hide. There's no problem. We're only going to look at it when you want to commit it, when you commit a crime. But what I say is, if you look at what the NSA has been doing in the United States, that's not true. What they're doing is they're running analysis on all of that data to find patterns, to figure out who you associate with. And if the person you associate with calls someone who's a guerrilla or a narco trafficker or an Al-Qaeda member, you're in trouble.
The information.
Yeah. And then they share it with each other. The U.S. is going to share the information with Colombia, and Colombia is going to share the information with the U.S.
There is this Google policy that if you don't have something to hide, so I mean, if you have something to hide, maybe you shouldn't be doing that stuff. But for example, being naked is not something public.
Sure.
And it's not something that I want to share because I want to keep to myself.
Right.
Or I don't know, anything else that is in my private stuff. So for me, it's this kind of a new kind of thought that is fine to have email or Google or stuff like that because I share that ethics, the idea that I don't have to hide. But it's not true.
Yeah.
Everybody wants his own privacy. I mean, it's the normal thing.
Sure.
It's kind of becoming abnormal. Like I need to be a transparent person because I have nothing to hide. That's not the truth. And for me, like taking this kind of policy by using this infrastructure is like sharing this effort. The idea that I don't have nothing to hide.
Right.
So I don't have right to privacy.
Right.
And it's not the same.
It's not only that, it's that we must assume that the government has good faith, but the government can't assume that people have good faith. So why should we trust them? You know, that's the main issue actually. Because, for example, in my country, Venezuela, I mean, I don't trust in the government. So why should I trust them to have all my data and be locating me? Because they might say like, look, what you're doing is wrong.
Yeah, but
And I think what they're doing is wrong, so it's very subjective.
Yeah,
And they have the power.
for me, it's not about even government. It's about changing the reputation about privacy. Right? I mean, why you choose us in Google and not in government? They have even more power than government to cross that.
and make
that's volunteer. And instead of the government, it's not volunteer what I'm giving them, or if I can stay there. And not only that, I can actually, yeah, it's not only that, I can actually just decide not to use dual services.
Yeah,
But I cannot decide to the government, say like, look, I just decide to don't be, well, yeah.
Yeah, I understand, but for me, the main issue is changing our expectation about privacy. Like privacy is something against having something to hide. Like if the anti-natural thing. And for me,
But I think part of it is, there's two things I'll say on the I think the issue is, privacy isn't like zero sum. It's like, I can keep some things private that I don't want other people to know.
Yeah.
And that doesn't mean I have a crook or a bad guy. It's like, it's actually, we kind of don't want too much shit, right? Like, there's something, TMI, like there's something like too much information. Like, I didn't need to know that. We say that as a joking way, right? It's like, the reality is like, there's something I don't need to know. And I'm better off not knowing about it. And it's not bad, it's nothing personal, it's just, that's what we've expected as a society. The problem is the law is not flexible in that way that we as, regular people are. And what we're trying to do is to change this. The second thing I wanted to say is, we don't have to say it's, who is the worst actor, government or private industry. They're both, okay? And they're both there. I focus on government because that's my background and that's my expertise. But we also, we talk about private companies all the time. We say, private companies, you have a stake to play in this too. You shouldn't craft very broad conditions that say we're going to disclose your data whenever we feel like we need to disclose it. You shouldn't be burying what you're doing in unreadable terms of service. You should have all of your, bad private settings be opt. You should be default. The default should be that you're opted out unless you affirmatively opt in, which is not what most companies do. You should stand up for your users. You should minimize the data you collect. Like if you're a flashlight app, you don't need access to my contacts for it. Okay, so there's room for work on both. I'm focusing on government, but I think your point is taken that the government, the companies have a role to play in this too. And we've been talking about the 13 principles, and people too. I mentioned that about we have responsibility also to not be stupid about how we treat our data. Like I'm not going to put my social security number on the internet because I'm going to get my identity stolen. I don't put my credit card number on my Twitter feed because I don't want my money stolen, right? And it's got to be a balance of all of them. No, sorry, I'm sorry, I forgot. No. Go ahead. Okay, go ahead.
It's just a quick thing. The concept of being stupid nowadays is a very complex thing. There's like, however, you tell your mom, yeah, anybody can get her data just because she's online. No, it's not being stupid. Nowadays, things are much more complex, and it's not only ignorance. Things are much more complex. The technology has gone to a place where this is not like your day-to-day knowledge.
Communicating with encrypted emails is not an easy thing. And it requires a level of sophistication that most people do not have. And I pride myself on being a little bit sophisticated technologically, and probably much less compared to you guys in this room. But I know how to send an encrypted email. But it's a giant pain in the ass to do it. And it requires a lot of help. And it took me a while before I found it out, right? And the thing is, we have to have our technologists, they have to work on making it easier to use and create a better system. And I think we can do it. It's going to take some time, it's going to take some work, It takes some effort, but I think there's an interest there, and I think especially after Snowden, that's what there's a subset of that is going back to what I was saying, the companies have to feel pressure that they have to be restricted in what have to start to do that too. And it's not just talking to the people who are interested in tech policy, or engineers, who understand this stuff. We have to expand the group of people who do it. You know, they did a survey, Consumer Reports did a survey in the United States. And they surveyed people who have a smartphone. They found that only 35% of people who have a smartphone actually have a PIN on their smartphone. You know, the 4-digit code you push to unlock your phone? Only 35% of people who have a smartphone in the United States actually use the PIN, okay? And the majority of those people, probably their password is 1111 or 1234, something simple, right? You have to change the approach of the 65-year-old, of the 20-year-old kids who are posting stuff on Twitter, not realizing the consequences. It's still, I think, I think the internet is constantly changing, but we're having a whole generation of people who are growing up plugged in from the minute they were born. I didn't get my first cell phone until I was in college, right? I have a daughter, she's 15 months old. She knows how to she knows how to put in the password. She finds YouTube, the YouTube app. That's the only app she wants, and then she'll find the video she wants. She's not even a year and a half old. I swear to God, she does it. And I change the password. She figures out. She's very smart. Yeah. She's gonna grow up with a phone or a tablet in her hand. That's the future. It's very different. I played with a toy phone, the green plastic one with the cameras, right? She's actually, we bought her a toy phone. She does not want the toy phone. She wants the real deal. Yeah. She knows how to close the app. She knows how to get back to the home. I mean, she knows how to do it all. Yeah, well, you had a question, right? Yeah, you wanted to say something.
But you said, but I. In what level of risk are, for example, journalists, activists, you know,
Yeah. So that's a problem in the United States. That's a big problem in the United States. We have a lot of examples of this where very aggressive surveillance techniques, very aggressive laws are being used against journalists and activists. I was talking about this earlier at part of my life, but I think they especially have to be aware of it because they do have something to hide. Not simply their own personal things, but they have to hide their sources to protect those sources. They may have classified or sensitive information on their machines. And so if you're an activist or a journalist, you have to be very, very careful with what you're doing, very much aware of how the government can get access, not only legally, but technologically. I mean, look, the government has malware they can use. They have all sorts of crazy stuff that they can use. And like I said, we have it in the U.S., which means you guys have it here too. You know, they can record keystrokes, they can get you're sending a message right now on your phone, right? They can see what you're sending, they can remotely activate your cell phone camera, your webcam on your laptop. They can do all of this stuff. They can take your keystrokes, I mean, stuff that you would expect, you know, some black hat hacker who wants to steal credit card numbers is doing. The FBI is doing it. We've documented that they do this. And so you absolutely have to be very, very careful.
Voy Barreras, Mario Gracias.
One of the people this order and this material is selective criminalization. I mean,
That people, yeah.
in the case that you say about the man who was looking for drug dealing, but he got caught by shooting his gun.
Right.
I mean, that's a kind of selective criminalization because you want to talk him, so you start to look at him all the time, and sometimes he's gonna say, "It's not that thing, I take him."
Yeah.
So it's like
He was Mexican. He has a Mexican and eastern, very rural part of Washington State. Of course, they said, Mexican, he must be in the drug trafficking, right? And, you know, he wasn't. I mean, he had drugs. I'm not saying he was innocent, okay? But it was a pretext, right? And that's the problem. And that's what happens with some of this aggressive surveillance. Especially when you start to think about, like, if you start to think about class, okay? Like, who's more likely to live in a small urban area where there's lots of security cameras, right? It's the person who can't afford the big gated mansion, who can't afford the private neighborhood, who can't afford the living stuff, okay? So when we talked about, we were talking about earlier about predictive policing, and I was saying, question what is the data that's going into it? Well, they all lead, the one leads into another. You know, if the surveillance is happening in the poorer neighborhoods, you're capturing more of the crime there, and then you use that data to create your algorithm is going to tell you to keep looking at the same neighborhood you go looking. It doesn't matter if it's a computer that generates a computer. And then you have the selective prosecution. Whereas, you know, maybe there's more crime happening up in the hills in the rich part of town, but they don't have the cameras there. Yeah, you know.
When you think about the surveillance for the United States or other countries,
Oh, that's
I
cool.
suppose that it's actually the same, but in a different state.
It's actually worse. Okay.
When we think in our defense is actually impossible because we are not U.S. citizens. So we don't have any law that protects us for the survival of the country.
Oh, I know. I'm very sorry about that. I had nothing to do with it. I did not agree with it.
Or all our tools like phones, laptops, or computers are taken international. So that's terrible. I suppose that maybe someday we can find a new process that can.
Yeah. Let me talk about that for a minute, because that's actually a great point. So when I said it was worse, again, my focus is always on domestic issues, and all we've been talking about here is trying to figure out a way to get the surveillance into the Constitution protection, which then triggers a search warrant requirement, which is the safeguard. Judges review. The problem in the international realm is that if you're not a United States person, it does not matter. They can do, at least under U.S. law. I'm not saying under international law, but under U.S. law, they do whatever. It does not matter. In fact, under U.S. law, if you are a U.S. citizen and you're abroad, there is even gets abusive people in the United States who, you know, communicate with people across the world. Like, we exchange emails. My family's from Egypt. I have family in Egypt. My wife has family in Egypt. We talk to people international all the time. Why should my conversation now all of a sudden lose protection because the person I talk to is in Egypt versus the United States? It doesn't make sense. What we is a set of goals or a set of principles that EFF and Karma and a whole ton of organizations across the world, over 400 organizations across the world, have come up with a set of frameworks by which we can say, look, if a country wants to do surveillance, whether it's on its own citizens within its borders or on other people outside of its borders, regardless of nationality, there's a legal framework that they should follow. And that framework is actually basically not only the search warrant requirement, it's even a stronger requirement. And so one of the things that we're going to be doing when I'm here on Wednesday is when I talk on Wednesday, is to tell the leaders of your country that they should keep the principles in mind and adopt them. And we do the same thing in the United States. We're trying to convince our leaders to adopt these safeguards as we challenge what the NSA is doing, because we don't like things. EFF has sued them, we sued them twice now over this, and a big part of it is that what they're doing is abusive and aggressive towards Americans, in the United States, but also to people in other.
What about human rights, privacy?
I'm sorry?
Human rights declaration of privacy.
So the 13 principles basically are built on the Universal Declaration of Human Rights and all of the international treaties that have basically put in place an international framework that recognizes that people have a right of privacy and also, importantly, a right of association. That I have the right to be able to communicate with you and associate with you without persecution or without being punished for the fact that you and I are communicating. So our 13 principles adopt some of that framework, or not adopt that framework, it's built upon that framework. It's the foundation of it is international human rights law. And basically the 13 principles says, look, if you as a country want to engage in communication surveillance, the way you do that consistent with your human rights obligations is by doing the following, and that is you have a very compelling interest, you have certainty that you're going to get evidence of a crime, there's procedures in place to minimize the collection of data from third parties who are innocent, you are going to delete the data as soon as you no longer need it, you're getting judicial approval for it, which are, by the way, none of these are the things that the NSA was doing when they were surveilling everyone, right? And everyone in the United States still are, I know, right? They weren't doing any of this. And so what we've been trying to say is they have to do those things. We have to impose those sorts of restrictions. And in fact, on the telephone records program, you know, the President Obama basically commissioned a report to analyze the phone records program, which collects the data of all the phone calls that, now they're looking at all the phone calls that people in the United States make, and in that report they actually cited the principle. And they said, you know, there's a real push that says, you know, just because this is communications data or metadata, it still is subject to expectations of privacy. Now, that's a very small step in a larger goal we want to do, but that legitimizes the principles. If you have the President's own commission that's set up to study this, is referencing the report, you know, the principles that we put together designed to kind of provide legal protection for foreigners, for everybody across the world. Again, it applies to a state whether it's doing surveillance of its own citizens, which is basically what I've been talking about, or we're talking about the NSA context where they're trying to do surveillance or spy on an international country or the whole world. Again, I thought part of that.
How safe? Well, I know that we may take it we don't do that, but how safe is it? You know, how almost feel that you so something real keeping the overseas. Yeah. It's going to depend on the country and the company you're keeping the data. So, you know, some countries have very strong data protection laws. No, please. I will talk to you through the... Oh, Linux? Is it on Linux? Oh, I'm not sure.
The only one thing that you said is because you can see what people in the info.
Yeah, it's harder to have like backdoors and sort of that. Because there is a lot of people like creating for bots and this kind of nasty stuff that other people that don't have to deal with their source code is doing with the operating.
I can't forget what I to the problem is not going to surveillance to protect no, instead where the government says, for example, I am disagreeing with the government and the government says that is bad.
Yeah, we have the same problem in the U.S. where the government selectively persecutes some people. It's, this person is a threat to the state, that's why, the government is investigating WikiLeaks. The U.S. government is investigating WikiLeaks for 4 years now. Julian Assange exposed some very embarrassing things with the U.S. and is very unhappy with that. Or Chelsea Manning is in prison for 35 years because, she exposed very embarrassing information. The U.S. Army killed innocent people in Iraq and Afghanistan, and they're very upset about it. And we absolutely have that problem, and it's actually gotten worse. We have the kind of push towards hacktivism, and the law we have, again, we were talking about this earlier, the law in the United States is very similar to the law in Colombia, the anti-hacking law. And the problem with it is the punishment is very tough, and it criminalizes things that aren't hacking. It criminalizes, violating the terms of service could be enough to fall under this stuff.
It's like use a computer.
Right.
As just like going to a website.
Going to a website can be unauthorized access. Going to a public website has been said to be unauthorized access to protect people. And so all of those things are big problems that, again, there are many, many problems, right? That we have to take small little approaches. Our approach is to take small little fixes. Because we're not going to fix everything all at once. We have to just kind of start slowly. So what I've been talking about is the efforts we've done in the United States to show, look, on the surveillance issue or on the right of privacy issue, you have to take this approach where you start to thinking more sophisticated about some of this stuff. Let me go back to the presentation real quick because I'm almost done actually. But and a lot of this stuff I'll go through quickly. Like this was the case, that there was a case in, again, 1988, the court said you don't have an expectation of privacy in your garbage that you leave out on the street. Okay, what happened in that case? The guy left garbage out on the street, the cops went to look through his garbage to see if there was evidence of drugs. And they found it and they charged it. So the court said, when you leave your garbage on the street, anybody can just go pick it up, so you don't have an expectation of privacy. And, I don't know how true that is. I mean, I saw a couple of people here picking garbage. I see it in San Francisco, people pick garbage, almost guys that pick garbage. Okay, maybe that's one thing, but I don't expect the police to come and rummage through my garbage, if I live in a residential neighborhood. That's kind of weird. I've never seen that before. And then the issue becomes, what about all this data that's stored in all these companies? If we don't have the expectation of privacy in our garbage because somebody can look through it, then necessarily all of this data can be looked through. We've already talked about that. So this is another case we were talking about when you get arrested, the police can search your cell phone. This is a case, Robinson was a case in the 1970s that said, okay, when the police arrest someone, they can search that person's pockets and they can search the areas around the person. And then Robinson, the court was looking at a pack of cigarettes. They arrested this guy, they took his jacket and they felt his jacket and they felt a box. They took the box as a pack of cigarettes. They opened the pack of cigarettes, they found cocaine. Okay? Of course, they had no problem. You can search a person in the mail. And you can search the items on them. So now the issue is cell phone. Can they do that with a cell phone? And the issue is a pack of cigarettes the same thing as a cell phone? Right? Well, obviously it's not, right? The cell phone carries way more information. The government has actually argued the same thing as a pack of cigarettes. The legal protections for the Supreme Court is actually, they're deciding this issue next month. They're going to issue their ruling. They have 2 cases where this issue is up, and we'll see what they say.
If you have a thing on the cell phone,
no. Just because, let's say the court says the police can search the cell phone. They are allowed to search the cell phone. They do not have the right to be successful. Okay? They have the right to search. But if you have the PIN, and they can't get around the PIN, just because they have the authority to search does not give them the authority to punch you in the face and make you put the PIN. Okay? Now, what they're going to do, what I've seen a million times, is they're going to ask you, hey, do you mind putting in the PIN? And you're going to go, sure, yeah, no problem. I've got nothing to hide. They're going to go easy on me, and then they get all the evidence and they throw you in jail.
What happened when you walk to the airport and you take
The computers.
Huh?
Exactly.
Yeah, but actually the bigger problem in the United States is at the airport, if it's an international airport and you're coming from an international flight, you don't have a right card. So when I'm coming back Thursday, my flight's in Miami. The police want to search my phone in Miami, they can just say, we're going to search your phone. They don't have to have any reason at all. They can say, we're going to search your phone. Deal with it. And I can say, no, I'm not going to turn it on. And then what they're going to say is, okay, well, you're going to go spend the night in the jail cell, and then we'll see how you feel about it.
You're gonna say, I'm a lawyer.
Well, it's not like that. It's not like that. I mean, if you're a foreigner, you're not a US citizen, they will say like, okay, so they might,
We're not letting you in unless you stop.
or they could get you into a jail and that's not in US jurisdiction. So it's, what you should do is not getting data you don't want to be seen. You know?
We have a
Just
travel
like-
guide. We actually have a travel guide for people coming into the United States with electronics. We have some tips. And basically our tip is don't bring your shit.
Yeah.
If you don't want it searched, don't bring it. Or bring a dummy computer. Like bring a computer that has nothing on it. Or wipe all your stuff and back it up in a server somewhere and reload it up once you get in the United States. So if you don't want to sit at the border, don't bring it.
Yeah.
That's my advice.
Yeah.
Next time you come to
Yeah.
I see there's, like, obviously there's a big concern on the government's abuses of people's privacy, no?
Mm-hmm.
And there's another big issue, which is like corporate abuse of people's privacy, which is another big issue. And then there is also, the, not only corporate abuses of people's privacy, but also corporate possibility of
Ratting you out.
yeah, not only ratting you out, but also they, as they are the ones controlling the instruments and the services and all that, they can perfectly get away with doing whatever they want.
You are saying.
Without, yeah, like, nobody, I don't know, the government is looking for criminals, no? And, but not
always.
ideally, not always, or looking for somebody to say that they're criminal or whatever. But then there's the like large-scale criminality of organizations and corporations and things like that, which are things which are always in that gray area of where you don't know, because you're not aware as a citizen of what they can or cannot do, or you don't know if they're committing a crime or not. No, so what happens with all those other abuses which change kind of the definition of privacy, or take privacy to the next level?
I'll give you an example. There's Google Street View? You can see a picture. So I think they did this, I'm pretty sure they did this all over the place, but when Google was compiling that data initially, they were war driving, okay? So what they were doing was, on the cars that had the cameras, they were also sniffing open Wi-Fi packets, right? And they said, oh, this to make our data very accurate and precise. This violated a lot of laws in a lot of different countries. In the United States, it violated the argument was it violated the Wiretap Act and it violated all these regulations. And in Europe, it violated all these EU laws. And, the regulatory agencies went after Google. And so in the United States, Google was ordered to pay a fine of $250,000 American dollars. Okay? Which is like, like 1 cent, right? Google, I think in Europe they were required to pay a higher fine and change their practices. And they agreed, they stopped doing it and they said, oh, we're really sorry, it was a big misunderstanding. The guy who did it, we fired him. And now you can still go look at Google Street View pictures. The problem is, the big part of the problem is the enforcement, the government's enforcement mechanism. The more effective enforcement mechanism is us. Like, we don't like a policy, we just leave. We vote with our feet, and trust me, they listen when we vote with your feet, because they want your business. So, when we leave the company, right, if you say, Google, I don't like your practice, I'm going to use your company, I'm going to use DuckDuckGo to do my Google search, to do my web searching, because they're anonymous and they don't put ads, and, Is DuckDuckGo going to replace Google? Probably not, but at least it puts pressure. Google says, okay, fine, we'll change our policy, we'll change our internal policy, we'll hire one, we're going to SSL encrypt everything, end to end. And sometimes they do it in a way that pisses off the government. So for example, Apple, iMessage, you can send messages between different users, like say an Apple device. iMessage is encrypted end to end, and it's encrypted on the server. That's what Apple says. So the DEA, so the Drug Enforcement Agency in the US, is very upset about that because it's very hard for them to get data from Apple iMessage. Okay, it's now turned out to be kind of a secure issue. And so, they're mad and they complain and they go to Google, Apple, and Apple's going to keep it this way. And so that's a way. That's a way where the company can thwart some of those things. It can be both a factor, a good thing and a bad thing. But I really think it's about voting, taking your business elsewhere. And that goes back to what we were talking about earlier about technological solutions to some of these problems. Right? DuckDuckGo is a good alternative to Google. It is not as great of a search engine as Google, but it's a privacy protected one and it's free. We have to make the cost of privacy low. We need to encourage more companies to be end-to-end completely encrypted email. And we are trying, again, BFF, one of the things we do is we put pressure on the companies to change their policy, to do some of those things to protect their privacy. I don't think they make any money. I think that they basically are doing it because they believe it. They're doing it out of ethics and morality.
They make a lot of money.
My understanding, I thought he didn't, and I'm not a paid sponsor of them. So, I'm not entirely sure. My understanding was they didn't make.
They make money. I use certain club, and the guy is making money from two sources. One is he's a venture capitalist, so he has his own money. But I think he has his own money, but also he's trying. No, I'm not. But he's trying to create like something that is not about your personal history, about searches, but your terms of search, something like that. So when Google is profiling, they create this bubble about you, about all your cookies, all your stuff, all your and this guy from DuckDuckGo says that you don't like to do search like that. You read good what you are looking for. It's true. You don't hide stuff on the search that. So he's trying to make like targeted ads about your search, not with all your profiles.
They're not following you.
Yeah.
And selling your information to some other company who then.
Are following
No, in fact, no. No, only terms. The terms like
Search about.
Yeah. These terms, only the terms.
Yeah.
So they use
like you're looking for a booth for sneakers, and they show you like Nike sneakers, Adidas.
Yeah. Just the terms, not for finding it. That's
Because if you use Google and you do a lot of searching for sneakers, they're going to show you Vans.
And you might be doing search for a booth.
Or Vans sneakers in San Francisco, 5 blocks from my office, are on sale on Saturday after 6 or something like that. Very more targeted.
Actually, they do your profiling based on age, gender, race, ethnicity, everything. So if you're a foreigner or not, if you have been traveling and stuff, it's actually kind of worse. And these guys are you don't need all that to do advertising. You can't just do it with the search term in that moment. You don't need to store it. You're just like, look, I need ads for this term, get it back and don't store it. So that's the DuckDuckGo kind of business. Yeah. That somebody who's not doing money actually is Telegram guys. I know that. I mean, we're very rich. They are not doing any money.
But then we also have to, part of it, what I think you're kind of getting at is like we need to create a market incentive for companies to do that. Look, probably no company is going to get rich like Google rich, like billions upon billions of dollars making pro private stuff. But if you can create systems whereby people can make money to not only cover their costs but make some profit, and if you put the cost structure in a way where, like, I'll pay $5-10 a month for some real good privacy products if they'll work. Okay, I mean, I'll pay $100. You know, I don't know. I mean, everyone's gonna have to make a decision. But if you put the barrier to entry low, and you create some sort of incentive, and the way you do that is you get enough people who are interested in those things, then maybe you can make some inroads. But right now, I mean, it's just people want Gmail, and they're willing to pay for it by getting the track and serve targeted ads. But if enough people start to say, you know what, that's fine for you, but I'm opting out of that system, and there'll be more. The market will respond to that demand for the service.
Just like organic food, you know?
Oh, yeah. Correct. Yeah.
And the ultimate regulations say, hey, you offer email service, you have to you have to protect privacy.
I think that's gonna be the market.
I think that's great in the abstract. The problem becomes tech mandates is always a big thing we worry about. Like, that's a good tech mandate. But once you establish the precedent that the government can tell the company how to manufacture its hardware or software, well, where does it end? What if the company says, you have to, what if they say the opposite? What if they say you have to build a backdoor into our system? Actually, in the United States, telcos are required to be able to be wiretapped. So if you're a phone company, you want to start a new phone company in the United States, you are required under law to configure your architecture to allow the government to install a wiretap. It does not apply to, yeah, I'm sure.
The GSM can be encrypted. Well, you have to deactivate it. Yeah. So that was one of the main features of GSM that never got to be used because that had.
Now, that law only applies to telephone. It does not apply to internet providers. And so there's been talk of changing the law to make it apply to internet providers. And there's resistance to that from the companies. The companies that resist, the big companies resist not because they care about privacy. They don't want to spend the money to do it. And they don't want to change the way they have their systems set. And then there's resistance from organizations like EFF that say this is a really bad idea because when you create a backdoor for the government, you create a backdoor for everybody else. You create one for the bad guys too. You can't create only a good guy only backdoor. It doesn't exist. Okay. And so it hasn't gone anywhere in the United States, but we're on the lookout for it. I put this slide up because, and this is basically the end. The same court that said this expectation privacy test, they really, this is how I think we have to address the issue in the future, is that information you seek to preserve as private, even in an area accessible to the public, should be constitutionally protected. And that's what we've really been talking about. Your location, your stuff you store with your emails, your Facebook postings that are only private, that are not for everybody to see. If I intend to keep that information private, and it's somewhat reasonable for me to do so, okay? I'm not saying that, I have a right of privacy to everything I say right now, even after I agreed 20 times and you guys can record what I said, right? That would be unreasonable, right? So I'm talking about reasonable expectations, then it should be constitutionally protected. And, this was the example, this is one court that talks about the example of discrete movements may not be protected, but your whole movements are protected. So that's one example of it. And then basically, this was from one of the challenges to the NSA's cases that was brought by the ACLU, not by the ACLU, sorry, but from other organizations. And the judge basically, it's a very long block, but basically what the judge concluded in this case was the technology has changed and it's time for the law to change, and that time is right now. And so that's basically all I have. This is my contact info if you guys have any questions. And I'm happy to stick around and answer as many. I know I've talked for a really long time and it's been 2 hours, so you're free to leave and whatever, but thanks very much for having me. I'll stick around and I'll answer.
I will make an add. Now that you listen, Hanni, it's very important to create mail and the things we are doing. Bueno, en español estamos haciendo a los jueves, le llamamos Criptopía, le puso aquí le pusimos Criptopía y son como Crypto Parties. Todos los jueves, 6 de la tarde, este jueves, PGP